Yes.
Jump out of them.
Yeah. Yes. Prakatla, we are not ready. We are not ready with this. I think we just finish. Next date we deliver judgments.
Balasana.
Yeah, not this fixed for filing of police prohibition. We are not the I informed the claimant because he was in Manipur. You know, he had some stuff there because due to some emergency.
Yeah, go for national insurance.
So I paid for a fund next day and along with the one of the additional document that is certificate on the
Counsel for the claimant PPD. Praise for time for filing the list of witnesses. Learned counsel for OP National Insurance. Learned counsel Ian Rambai for the OP National Insurance present. Prayer of the claimant allowed. Fix for filing list of witnesses and documents.
you know I placed my some citation.
How much compensation you asking?
This one you know around 35,63,000.
Ex party hearing concluded. Fix for judgment. Yes.
Tu bentana. Porcela. Presentron.
Under section?
Under section 302.
Hmm.
The incident occurred on the 23rd 4 2016 at Hali Lanak Lombakwa around 2 p.m. And after the incident, the FIR was lodged on the same day by the PW1, who is the wife of the deceased person, PW1. And then the case was registered under White to IPS case number 85 of 4 2016 under section 302/34.
Incident occurred when you say?
Occurred on the 23rd 4 2016. FIR was lodged on the same date by the wife of the deceased, PW1.
Yes.
Then the case was registered under section 302/34.
What is the allegation
And
there, sir?
it's that the deceased person was murdered by the accused person.
Let's read there.
I'll come, sir. I've just finished this. Sir, and after the investigation has completed, the charge sheet was filed against only one accused because one of the accused is not involved in this case. So he was discharged by the
Who are those two
IOPW7.
accused? Both were named in the FIR.
Both were named in the FIR.
All right. That's why I
Yonis
said that.
and Lianwell.
Let's say that's
And
why we want.
Lianwell was discharged.
That is what we want to read the FIR.
Nga siya bahaban pentip siya ke burong besbon jong fi ba nga ke Helen John sai twai na ke snong mengor nga pentip si phi ba ha ke arpulai trik benai ba sau arjar arpul khandrio ha ke por ar ba a katba ulok jonga ma kala rupon the disease udang don hebri jongi ban reps ing ka bekerteng hali lanak lombak kwa kensan lawan u Yonis kendai Lianwell sai twai bat ki perlok jongki
Eunice
kendai Lianwell sai twai bat
Lianwell. How do you
Lian
spell it?
Lianwell
L-I?
Lianwell sai twai SAITHWAI
S?
AITHWAI bat ki perlok jongki
Yes.
ki la pom penyap ya ulok jonga da ko wait na rendang Hashwa ba undukot mensin uli yo ban ye tho ya ka kerteng jongki ni kinong penyap. That is the dying declaration. Kumta la kerpat
Ula
i
yo
bakin.
to kerteng. To whom?
She has not mentioned that. Then I'll come to our evidence.
All right. Then who was discharged? Or everybody was discharged?
Lianwell.
No. I want to know. Let's just get the factual aspects correct. This FIR was filed. The allegation in the FIR was the involvement of the accused persons who standing for trial, along with another accused persons and their associates.
Yes.
Okay. So during investigation, was the investigation carried out against all those persons who have been named in the FIR? Associates
Only these two. Associates, no. Only these Yonis and Lianwell. Because this Lianwell is surrendered for the police and then he was arrested.
All right. So he was discharged.
Yes.
Yes. Discharge. And then charge sheet was filed when?
Charge sheet was filed on the 23rd 9 2016.
Number?
CS number 120 2016.
Under section?
302 IPC. And a charge was framed on the 19/12/2018.
Yes.
under section 302.
Yes.
I'll go to the evidence of PW1,
Who's PW1?
the wife of the deceased person,
Who
who
filed
is
the
the
FIR?
complainant.
She's the informant?
Yes. And she stated that on the day of the incident, she was at home. And one person by the name Lamprang Potang came to her and informed her that her husband has been murdered. And on receiving of the information, she intended to go to the PO, but they did not allow her. So she waited at home. So then when the police came to her house on the date of the incident, they proceeded to the PO, and then the dead body of her husband was brought to her house in the evening time.
1 second. Read the evidence again.
I received someone to appear before the court. I know of the case as I am the complainant. The incident occurred in the year 2016. On the day of the incident, I was at home and one of my co-villagers by the name Lamprang Kothang came to my house at around 2 to 2:30 p.m. and informed me that my husband Kalarupan was murdered in a place called Lom Bakwa. On learning about the incident, I intended to go to the PO, but my relative did not allow me, so I waited at home. The police came to my house on the day of the incident and then proceeded to the PO. The dead body of my husband was brought home in the evening around 6 p.m. and his funeral was held on the next day. Later, I learned that the accused person, Yunis Kandait, committed the crime as told to me by my co-villagers. Then the FIR was lodged.
Have you reconciled this evidence of PW1 with the facts stated in the FIR?
Yes, she's silent with the dying declaration.
Yes.
Yes.
That's why I asked you, the dying declaration was made before whom?
It was
No. We have not come to that stage. We are only examining PW1 because she is the informant.
Yes.
The informant has stated in her FIR
Yeah.
that the two accused persons were involved. Not only two,
With
the
their
two
other
accused
friends.
persons were named along with their associates, and a dying declaration was made.
Yes.
But she did not say that before whom.
Before whom, no, she never stated.
But before this court,
The witness came.
we will come there. Before this court, when she came as a witness,
She's silent.
she's silent about dying declaration
Dying
being made,
declaration.
and she says that she came to know about the incident from the co-villagers.
Yes, that it was Yunis who murdered her husband.
Co-villagers told her
Yeah.
that
Yes.
all right. So with the facts, there's no consistency in the facts in the FIR and the
So,
evidence given.
I will link this after we come to the dying declaration, whether it's true or not.
Okay.
Because in her 164, I'll read it in her 164 statement.
Her statement was recorded under section 164.
Yes.
Exhibit.
Exhibit 2. Exhibit 2, recorded by PW 13. Because here she is. In Exhibit 2, she stated that I'm appearing before this court so today. It was on Saturday around evening time. Sri Langja, this is PW3, came to her house and informed me that my husband, Kala Mitre Rupan, was murdered by Yonis and Lianwell Saitwai at our own field while he was cultivating ginger. Because this PW3, the deceased made a dying declaration before this PW3. And after that, he went to inform the wife.
Look at the evidence of the PW1.
Yeah,
She says that A co-villager by the name of Lamprang Kothang.
Yes, sir, there is a contradiction with the name. But as per the evidence of
No, it is not
PW,
name.
but as per the evidence of PW3, it is he who informed the relative.
But she says she was informed by Lamprang Kothang.
Yes.
And she's silent about that, what she said it came. Her evidence 164 is one. Her FIR is one.
Is what? And
Her evidence before this court is another.
yeah.
That-
There's difference.
Yes, next.
So I'll come to the evidence of I'll club it together, this PW2, PW4, PW5, because they were together.
Where?
They were together in the
PW?
field when they saw this deceased person lying dead. I mean, he's still alive. When they saw him, I'll just read because these
PW?
three,
PW?
they were together. PW2, PW4, PW5. All three of them were together.
PW?
2, 4, and 5. These three witnesses, they went to call PW3. Because these three witnesses, they saw the victim lying on the ground with his face down, and they went to call PW3.
Let's see PW2.
The incident occurred on 23/4/2016. On the day of the incident, I was at a jungle known as Baku for collecting vegetables. On that day, I was with PW4, that is Rachel Watson, and Eileen Satwai, PW5. Then we saw the deceased lying on the ground with his face down, and then we went to call Nenjer Mursum, PW3. And then we returned to the place with him where Sri Kala was lying, and other people had also reached the spot. When PW3 inquired from the deceased, then the deceased informed PW3 that Yodis and Lien Well had assaulted him from the backside of the neck, and I had also seen that there was an injury cut mark on the back of the neck on Sri Kala. And I'll read the evidence of PW4.
No, you are very conveniently reading the evidence. But then look at the evidence which has come.
Yeah.
Now, if dying declaration says
Yes.
that, we start with that
Yeah.
dying declaration is that the two accused persons were involved.
Yes. See, sir, as per the evidence of PW3, where the deceased made a dying declaration, he stated that only one accused, only Eunice.
But look here.
Yeah, that I'll come later, sir.
Okay.
Then he said that. Then I asked him who had assaulted him, and he told me that it was
You reading
Eunice.
you read PW?
PW3.
Now PW2.
I'll come to that later, sir. I'll finish with this PW3.
Okay. Yes.
This because PW3, he said that it was Eunice who had assaulted him.
Let's read PW3.
The incident occurred on 23/4/2016. On the day of the incident, I was in the jungle known as Bakur. While I was walking, three women, that is this PW2, PW4, and PW5, came and informed me that something had happened to Sri Kalarupan, and then I proceeded along with them and also called Sri Pelin, Sri Plan Kotham, Sri Byangwar, and Sri Multi Mutsan, as they are also walking nearby.
They are witness in this case?
No, they are not the witness. On reaching the PO, I saw that Sri Kalarupan was lying on the ground, face down, and there was injury mark on the back side of the neck. Then I asked him who had assaulted him, and he told me that it was Sri Eunice who had assaulted him. Then I immediately left for the village and informed the relative of Sri Kalarupan. Later, I came to know that Sri Kala had expired. Then, sir, in the evidence of these witnesses, PW2, PW3, and PW5, they stated that They never spoke to the deceased. Only PW3 spoke to the deceased, and they heard that the deceased told the PW3
One
that
second.
both
One
Yonis
second.
and
One second. Let's come to PW2. You say that PW2, PW3, PW4.
PW2, 4, and 5
PW2, 4, and 5. They were there. They saw the deceased lying
on
with
the
his
ground.
lying on the ground with his face facing towards the ground.
So they
They
went
went
to
to
PW3.
PW3. So PW3 came and he
And
saw that the
he was
deceased was
lying
lying there with an injury on his neck. So
backside
PW3 spoke
to the deceased.
to the deceased with regard to the injury. All right. The deceased revealed that
That
Yunus.
Yonis, only
Alright.
Yonis,
All right. All right.
only one accused had assaulted him.
Yeah.
Okay.
Then back to
Now,
line
the
of
evidence of
first-
this
wait.
PW3.
One second. When the see, PW2 was there, na Nomdakhar.
Yeah.
The
Yes, I'll come to that.
Nomdakhar says
Yes.
that Nomdakhar says that he was there present when this PW3 was inquiring. When
Yeah,
Preeti,
all of them, they were the bystander, all three
all
of
right,
them.
but see what he says. Means
But they
he
never
heard.
spoke. They heard, but they never
They
spoke.
heard what the deceased
what the
spoke
deceased
to.
said.
They
Yes.
heard.
They heard
Inquired
that
from
two
Sri
accused.
Kalla, and
Yes.
Sri Kalla informed PW3 that Yunus and
And
Linwell
Linwell.
had assaulted him on the back of his neck.
All the three witnesses, they heard two names of the accused person.
Yes.
They heard all three of them.
Yes.
They don't deny.
Yes.
Yes, they are the bystander. They heard that the deceased said that both the accused person assaulted him, Linwell and Yunus.
Yes.
And then here, sir, and the PW3, he mentioned only the name of one accused. And one of the witness also, she confirmed because this PW4, she said that only Yunus, she heard only Yunus,
Who?
but PW4, she said that she heard only the name of the accused Yunus, whereas in her cross-examination, she confirmed that even the name of Lianwell also was mentioned. So regarding the names, that all the three witnesses, they heard two accused.
Hmm. Yes.
At PW3, he mentioned only one accused person. Okay. Your Honor, in this case, there is a possibility this witness PW3, before coming to the court, he is aware that one of the accused has been discharged. So that is the reason he felt that it is not necessary to mention the name of the other accused. Because why I'm saying this, Your Honor, because in his 161 statement, he stated exactly as he stated that both the accused person had assaulted the deceased as per the deceased dying declaration.
So what is your argument?
It's only in his evidence that
We got
one
your
of the
point.
accused silent and the other witnesses also that
We
too.
got your point. But what is your argument on that?
Yes, Your Honor, in this case, Your Honor, the IO, I would like to bring to the notice of the court, this PW7, he is the one who recorded this 161. Whereas in his cross-examination, he said that the deceased did not spoke to these three witnesses. Did not spoke to the three witnesses.
Yes,
he
it's
could
true.
not speak anymore.
Huh?
The IO, he said that the deceased could not speak anymore because the IO reached the PO after the deceased expired. So on this, Your Honor, because the evidence of PW4 or PW2, 4, and 5 is corroborated.
How?
It's corroborated with the 161 of the PW3 because in his evidence there is a possibility because he's aware that this accused has been discharged by the court, so it is not necessary to mention his name. That there is a possibility, sir, because these other witnesses, they heard both the accused person, and even in his 161 also he stated both the accused person except in his evidence.
No possibility. You are arguing a case on a possibility.
Yes.
Can
Because-
the prosecution rely on a possibility? Possibility belongs to their jurisdiction.
Yes.
Possibility, maybe.
Yes.
These are fundamentals of a trial.
Yes, I
Your
understand, sir.
your evidence has to pass the test of must, not maybe.
Because if you go through the evidence of
Yes.
these two, the PW 2, 3, 4, 5, and so on, so if you go with, if you look
No,
at the seizure, when the seizure was made on being led by the accused,
No, that I understand. Or we have not looked at
because
the
there is a
seizure.
connection with the seizure, because the seizure was seized on being led by the accused person, and then the accused person, he put his signature on the seizure list. There is a connection with the seizure and the statement of these witnesses that his
No,
name has
connection
been
is not
mentioned.
enough. The connection is good enough, but connection is, I don't think so. Connection will give rise to some kind of a suspicion. But the connection has to pass the test of beyond reasonable doubt.
Yes, Your Honor. Because even in the 164 of PW1 also, she received information from PW3 that that both the accused had committed a crime against her husband. These two names, except in his evidence, only one name has been
No,
mentioned.
why should we be selective?
The corroboration, Your Honor.
No, why should we be selective? If
Because
5%, the police will decide, the witness will decide. If a crime is against whom? State. So the witness will decide who should be punished. The police will decide who should be punished.
No, sir. Maybe
If there are 5 criminals.
No, I'm saying there is a possibility because.
No, we are not question of possibility. There is no question of possibility. Your argument, if you want to argue the matter is that, look, in spite of these discrepancies, still the prosecution case stands. Yes, these may be discrepancies, but these discrepancies are not so fatal that it will dislodge the prosecution case or make the prosecution evidence unbelievable. If you say that, yes, there might be some discrepancies, there might be some infirmities, but these infirmities are not of that nature. The gravity of the infirmity is not that serious that it falsifies the prosecution case. But what is emerging from the prosecution case is this, is that
Only one.
the FIR was filed naming not only two accused persons,
Yes, and others.
naming many other persons. I've gone through the evidence of PW1. The last statement of the PW1 is that she's illiterate.
Yes.
The FIR was prepared by the headman. What is written in the FIR, she does not know. All right. So that goes in the advantage of the prosecution. Though she has set the criminal proceeding in motion, but she has gone to the extent of stating before in the FIR that uh, uh, the deceased had disclosed before dying the name of the assailants.
Yes.
She states that in the FIR.
Yes.
But when she comes before the court, she's silent. One. Under 164 or 161, what she says? That was a substantive piece of evidence. Please remember one thing. Look at the meaning of the word corroboration. Corroboration is a support. What has been stated under 161, the facts cannot be used. Inadmissible.
Yes, sir, but if it's a dying declaration, the court can act upon it and it's admissible. I have one ruling with regards to this.
Dying declaration.
Yes, sir.
So, you see,
Because,
dying declaration will fall under section 32 of the Evidence Act.
yes.
We are aware that dying declaration is a hearsay evidence. Means somebody telling to somebody, isn't it?
Yes.
But it is on the principle, or there is some ethics involved, that a man will not die with a lie
Yes,
in his lips or in his mouth and meet his creator. That's why it is presumed that the man before dying will not lie. This is the principle, isn't it? We are not, there is no quarrel with the proposition of law that exception has been carved out with regard to the hearsay evidence, which is in the nature of a dying declaration under section 32. It is a substantive piece of evidence. But evidence which is admissible does not necessarily mean that it can be acted upon. it has to pass the test of being true,
Yes.
properly
Yes,
recorded.
it is scrutinized.
And see, if it is a dying declaration recorded before the magistrate, then I can understand. All right. The magistrate will scrutinize it, whether he's in a fit state of mind.
Yes.
All right. Whether he's in a position to make a dying declaration or not. All those things, magistrate has to be examined, whether he was in a position to make a dying declaration. Because you make a dying declaration, it's not that you're making a will, okay, in your deathbed. It's understood that you're making a dying declaration means you are disclosing the cause of your death to somebody else. What happens? What happens to a person? He makes a dying declaration, but he doesn't die.
It's not so. If the person is alive, then
What
it's
is
not a
the
dying
oh,
declaration.
he makes some declarations.
Yeah.
He makes some declarations before dying. All right, before dying. The word here before dying means what? What do you mean by before dying? It's me. I'll say he's going to die. What is that before dying? When a man believes that he's approaching death, or that is also one of the most important ingredients, that he knows that I'm approaching death, because he will not like to meet his creator with a lie on his mouth. He has to know that I'm approaching death. So if you please try to understand the distinction between the dying declaration in India and under the English law. Under the English law, dying declaration is still admissible if he doesn't die. But in India, if it's before the magistrate, it becomes a statement under 164. So you are right, the dying declaration is a substantive piece of evidence. But look at the discrepancies of the dying declarations. The informant says in the FIR that the deceased made a dying declaration. We give you that leverage, that the informant being an illiterate lady, somebody writes the FIR, something like that. Okay, fine. She comes before the court, no whisper about the dying declaration. All right. We can also give you some benefit that maybe she's an illiterate lady, omitted. No, she makes a statement before the court. One, she says that she was informed about the incident by this Lampran.
Two different names.
By somebody else, she was informed about the incident,
and in the
and
evidence.
she came to know about the involvement of the accused persons from the co-villagers. Silent about PW3.
Yes.
PW3, who claims himself to be a person before whom a dying declaration was made, he says that he informed PW1. PW1 never says that I was informed about the
In
incident.
her 164, she said that she was informed by PW3 in her 164.
That is worst. Which one will take it? The evidence which is there before the court or 161?
The evidence before the court.
So that is, where have she stated? If you are referring to 164, out and out, there are two inconsistent statements.
The names are different.
There are two inconsistent statements which cannot be reconciled. And then you come to the dying declaration, oral dying declaration. Oral dying declaration is very sensitive. We have to very carefully examine the oral dying declaration, because as you said that PW2, PW4, PW5 saw the deceased lying on the field.
Yes.
They did not do anything, they did not speak to him. They approached PW3, so they came back along with PW3. Till this point is okay. Now PW3 spoke to the deceased and inquired about the incident. All right. All those people, PW4, PW3, PW4, PW5 were standing there, isn't it? When the PW3 was, talking to the deceased. These PW2, PW4, PW5 heard the deceased saying the two accused persons were involved in causing the injury. Okay? Now PW3 comes to the court, who is supposed to be the person who recorded or who heard the oral dying declaration. He says only PW1, only the accused. So which one is true? And the PW1 says that both the accused persons. And worse, the person named in the FIR was discharged. During trial, evidence comes against him as one of the perpetrators. Tell me, with these infirmities, you can reconcile the prosecution case. Still, you can say that no, in spite of all these things, still I can convince this court that these infirmities are minor infirmities, will not dislodge the prosecution case with regard to the fact that the deceased disclosed that the accused was the assailant. In spite of all these things, it is believable.
Through the evidence of the other witnesses, there's nothing except these 2, 4, and 5 because
So,
they were present.
if this is
and
all right, there might be
seizure of the
this
materials.
inconsistency in the statement or any infirmities or discrepancies in the statements makes it very vulnerable, but not to be discarded altogether. Now, under such circumstances, what is the next steps which the prosecution has to do that? Yes, the evidence is a bit shaky. Now, you want to bring some stability in this evidence. How do you bring this stability in this evidence?
I have to bring it through the seizure. The seizure.
Corroborations.
The corroboration.
You have said that it may be shaky, but look, it connects. It fits. All right. Now you come to the seizure.
Seizureless.
You come to the seizure. The accused led to the seizure of the. Which is the accused who led?
It's the Jonas.
Jonas led
to the seizure of the.
Now seizure led by the accused. Has it been proved?
Yes.
Seizure being made is one thing. All right. Because when you say that seizure, anything the accused does during the course of investigation is not admissible under law. Statement of the accused is not admissible under law.
Yes.
Accused leading anywhere is not admissible under law. It's all hit by section. The law presumes that these things are done under duress, so it's not admissible under law. But only to the extent where the accused, while in custody, leads to recovery, that is admissible under law under section 27.
Yes,
but then section 27 also prescribes statutory protections that how seizure is to be made under section 27 in order to ensure all the vices of duress or coercion. Then it lays down the procedure. How? First, a statement, discovery statement of the accused has to be recorded in presence of 2 independent witnesses. These are not empty formalities. These are only to shed off the presumption of coercion. Otherwise, everything is like section 24, 25, 26 of the Evidence Act says that no, it's not admissible. Now, if a recovery has been made, that you want that it should be admissible and should connect with the oral dying declaration, then you have to establish that the seizure was made in accordance with law. Because we are going to use that seizure being led by the accused admissible. When does it become admissible?
Yes, because the disclosure statement was not recorded by IO in this case.
Where is the evidence that the accused voluntarily led? That disclosure statements, what is the significance of the disclosure statements? It is not only disclosure statements. Please remember, the evidence of the a person making seizure becomes little significant. The more significant is the evidence of the 2 independent witnesses before whom he made a disclosure.
These 2 witnesses.
That look here, I want to.
They don't know the materials.
That is very important because the police will always say that he voluntarily led us. But his voluntariness has to be testified by 2 independent witnesses who were present there when the accused made a disclosure statement.
They never stated that.
And then even if the accused, if you say the accused has led to the recovery of the weapon alleged to have been used, did he lead voluntarily? You may have forced, you might have kept it there. Bring the gun.
These 2 witnesses, they don't even
What
know
is,
from where the
I can
seizure was
agree
made.
that we are not totally discarding your oral dying declaration. Okay, we are not totally discarding it. But with these gray areas, it makes it very vulnerable. In other words, it's very shaky. So once it is shaky, you want to bring some stability by consolidating it through corroboration. Now tell me, what are other evidence which connects to the oral declaration? He said that maybe these people might have forgotten, because we are aware that the evidence comes through human process. Through human process means through human voice, human brain, human memory. So all these things are involved. There's bound to be some discrepancies. Sometimes the discrepancies may be very fatal, but we have to overlook it if there are some corroborative evidence which says that no, he may have said this, but look, he also says this, he also says this. There is consistency. But in your case, I find that there is a lot of discrepancies. But how do you consolidate it?
For this issue also, they stated that they do not know from where the material was seized.
That is insignificant. Seizure made by the police during investigation is one thing. Need not independent. It is not necessary to be established when the person who has seized himself can establish, and his evidence stands that he has made a seizure.
Yes,
Even the
stated.
independent witnesses, until unless the independent witness says that I was present there when the seizure was made, but what the police is saying that seizure was made from there, no, it was made from somewhere else. Then there is a contradiction. But if the seizure witness says, no, I don't know anything about it. Okay, but if he's not deposing contrary, that's all right. But the person who did it, we look at his cross-examination, it's believable, the IO seized it. But this is not a case of a seizure. This is a case of a seizure being led by the accused under section 27.
Yes, sir.
So please bear that in mind. What is the evidence which corroborates the evidence?
Only that,
Yeah.
the evidence of these, only these bystander at the time when the declaration was made and the seizures.
But it looks like this not very old case, 2016 cases. Yesterday also we passed a judgment, isn't it? Please read the judgment. I'm tired. I'm tired of holding up the police. In that case, the main accused was police. Was too old. The IO died. He was the police. The main accused was the police. He took 5,000 rupees to conceal that it was a case of a murder. And he said, you can bury the body, give me 5,000 rupees, and I'll say that it was an accident. It's a prosecution evidence. In this case, tell me one thing that what has gone wrong? When all the witnesses are coming before the court and saying that the two accused persons were involved in committing the crime, and the IO happily, he had a statement under 161, nah?
Yes,
Where the 161 says that two. Why did he discharge?
that's right.
Why?
Because there's
And the
been
IO is none other than the
advocacy
lady
case
Tinkra
against him.
Tinkan.
No, this art hearts are the IO.
No, she's a part of this case. All they are same. It's still fresh in my mind, that Garampani's case. Two women and a child murdered in the house. Highly misdirected investigation. She's the IO. Tell us, look at the investigation, the investigation, the manner in which the investigation was carried out. It does not give us confidence to believe the investigation. Forget about the evidence which has come trial. It looks like the investigation has concealed a lot of things from the court. And so obviously they file a charge sheet showing their nexus, showing their interest in the case. And obvious. See, tell us, we understand your difficulty, but then with whatever tools we have to work with that. Nah? Tell us.
From my side, only that myself.
Yes.
Yes.
Don't think for you also it's a cakewalk.
Yes, sir.
Don't think it's for a cakewalk.
Yes, yes, sir.
Hmm.
Start.
Yes.
First, I'll start with the FIR. We already read the FIR.
Yes.
The name was two accused and others. Start by that. And this PW1, when she came before this court, she stated that she was informed by this Lamprang, however not by PW3, as claimed by him. He claimed that he
Do
informed
one
me.
thing.
Yes, sir.
What we have discussed, don't repeat.
Okay.
Anything
Then
new?
I'll go direct to.
Anything new?
Okay,
Because
okay.
what's the point of? We have already pointed.
Okay, yeah,
we
yeah,
have
sir.
already discussed the
I'll go to this
discrepancies.
PW 10, you know.
Who is he or she?
He's the secretary on that time, you know. I'll just read, you know. In the year 2016, I was the secretary of Mangor village. This part, you know. Para 3. On the day of incident, two lady, PW2 Namdakar and PW3 Raquel Mutson came to my residence and informed me that Yonis Kendai had murdered the deceased Kalarupan. It's pertinent to inform, to mention, you know, this PW2 and 3 came before this court, or not 3. You know. This one is PW4, you know. These two ladies came before this court and informed us about two persons, Liangwell and Yonis. When informing to this PW11, they only named Yonis. Thereafter, on receiving the information, I, along with Srimati Helen John Saitwai, who is the complainant, went to Saitama outpost to inform regarding the incident. Thereafter, we, along the police, went to Puyo. After receiving information from both these ladies, he went with the complainant to the police station to inform. However, in that information, they stated Yonis, Liangwell, and others, not as what this PW2 and 4 informed him. He had some more and others also.
Who?
This PW11, he stated he and along with PW1 went to the police
One second.
outpost.
Are you saying that PW1 was the one who wrote the FIR?
No, this
The
one.
PW11?
It's not clear now, but they said that they're the one who went
Not
to.
clear means make
Yes.
it clear. Are you saying that PW11 is the person who wrote the FIR?
No, but they went along
Because
with it.
you look at the evidence of PW3, the PW1.
Yes,
You see,
it was the headman.
all right. Who is the headman came to the court?
No, but this P11 came to court stating that he and along with PW1 went to the outpost.
Who wrote the FIR?
As evidence of PW1, it's the headman.
Headman came to the court?
No,
Okay. You are bargaining PW10, huh?
PW11.
11. What it says? PW11. You pointed out somewhere.
Para 3 and 4,
What is this?
On the day of incident, two ladies named Nom Dakar and Rachel Motson came
Paragraph?
to paragraph 3,
Okay.
And,
Yes, okay, take a note of.
and,
Yes.
and in para 4, he stated he along with Helen John Saitwai, who is the
Yes.
complainant.
You mean to say your argument is this, is that the evidence of PW11 discloses that PW2.
PW1 and PW11 went to the police station to find
No.
Yes, after receiving information from.
This, who is this Raquel Motson?
That is
PW2 and
PW2.
PW4.
You mean to say PW2 and PW4?
Yes.
They informed PW11
Yes.
that the accused
Yes.
was the one
Yes.
who had committed the crime.
Yes.
And then PW11
When
along with PW1
to file FIR.
went file an FIR.
Yes.
But in the FIR, they have named so many people.
So many people. And others. Yes, yeah.
Right.
And coming in the court, this
But
same
how do you
witness.
say that PW11 is not the person who filed the FIR?
Yes, Yana.
PW11 is not the person who drafted the FIR.
But in what
Maybe they came to know
Maybe-
later on.
maybe this person now become a headman. That's also a possibility because in village they change. Because at this she stated headman.
Okay, we got your point. Yes, next.
Yes. And coming to the evidence of this same witness before the court, they named two persons. This both PW2 and 4, And coming to this PW3, the case like this, PW2, 4, and 5, they were collecting vegetables. They saw the disease lying on the ground. Thereafter, they called this PW3. They went and called and they came back. And this PW3 stated that, while inquired from him, he stated that it was Yonis who assaulted the deceased. In cross, he clearly stated that in chief that, then I asked who had assaulted him. He stated that. Where in cross, he stated that at the time when I was at the PO, the three ladies and myself did not inquire. That's big different thing.
Sorry.
At the time when I was at the PO, it crossed the
who?
PW3. In chief, he said it was he inquired from the deceased what happened to him. Where in cross, he stated that at the time when I was at the PO, the three ladies and myself did not inquire from the Kalarupon, but Kalarupon himself told me who had assaulted him. Asking who assaulted him, you or he. In chief, he stated that he asked from the deceased who had assaulted you. Where in cross, he said no, he said himself. He did not inquire. Whereas the other three witnesses claimed that it was PW3 who asking. Where in this statement of PW2 2, 4, and 5, they name 2 person, you know. And this PW3 name only 1 person, you know.
That we have already- we have-
yes. Even PW4 also, although she name only 1 person in the
That we
chief.
have dealt with.
Yes.
That we dealt with.
You know, coming to this.
Discrepancies in the oral right declaration. If you have something more to bring other than what we have pointed
Yes,
out to
I'll
the
come to that,
prosecution,
yeah.
you
And
can bring that. But don't repeat.
PW 5, you know.
Yes.
PW 5, she stated that in chief, I do not know Liang well in the last part, you know. I don't know Liang well in chief of PW 5. Where in cross, you know, it said, it is a fact that I know Liang well Saitwa and he's
Who's
from
Liang
that.
Well?
Liang well is the other person, you know, which was named. This person is flatly lying, you know. First stated that I don't know Liang well, and
Where?
in the last part of her in chief, you know, I do not know Liang well.
PW5.
PW 5. But in cross.
One second. Where it says I do not know.
In the second line, you know, the last portion, I do not know Liang well. I do not know who had been arrested in connection with incident case.
Are we reading PW5?
Yes, you know, PW 5. This alien site Y.
Where?
Next page. Yes.
Oh. I just heard people village. I do not know. Yes, he said I do not know. Then
it come to cross, you know, in
where?
In para 2, not para 2, line 2, you know.
Yes.
It is a fact that I know Liang well Saitwa and he is from Lat Mungwar. She even knows his village also, not only just his name, even they flatly lying. And even this PW3, you know, he claimed that first time he claimed that no, I asked the deceased what happened. In a cross, he stated no, we didn't ask. He himself who assaulted him.
No, yes, what you're trying to argue, I understand. You mean to say, without going into the merit of the evidence which has come, you say that the witness is not worthy to be trusted.
Yes.
You are questioning the credibility of the witness. That
I'll
is
come
not
more
worthy to be trusted.
Yes. I'll come more also on that. You know.
Yes.
It is to mention, you know, this from PW 2, 4, and 5, the three ladies. They said after seeing Kalarumpuan lying on the ground,
Yes.
they called this PW 3.
Yes.
They took them 1 hour going to call this. He was walking, this PW 3 was walking somewhere else. And they went 1 hour to call him. And they 1 hour coming back.
From where you see 1 hour?
There's in the evidence, you know. There's in cross also.
Yes. What is the significance of the
I'll
time
come
of
to
1
that.
hour?
2 hours, you know. It
1
took
hour going,
1 hour
coming.
going, 1 hour coming, 2 hours till they reach back in the PO to talk to him. I'll come to the evidence of the doctor. You know. He'll be PW 6, yeah.
Yes.
I'll come to para 1, 2, 3. You know. From the external appearance of the disease, so and so, you know, he sustained incised injury at the back of the neck, 8 cm depth, 6 m wide. The length of injury is 10 cm. You know, he was, you know, if I may, you know, this is the measurement of 8 centimeter, you know. This is the measurement of 8 centimeter, you know.
Small one. Yes.
This is a measurement of 8 centimeter.
No, just read again. I missed out.
Yes.
Please just repeat again.
Para 1, 2, 3.
Yes.
He sustained incised injury at the back of the neck, 8 cm depth, 6 m wide, length 10 cm. 8 cm depth, you know, on the back. That also in the backbone, you know. He also stated that there's a.
Once again, 8 centimeter
depth.
deep. 8 centimeter deep.
Yes, this is 8 centimeter deep on the neck.
Bring the scale.
Wide 10 cm.
8 centimeter deep, 6 centimeter wide.
Yes. That also on the backbone, you know.
The length of the injury is 10 centimeter.
This portion C2, C3 level, you know, that's in the neck, you know.
Yes.
So my argument is that it's humanly impossible for a person to stay alive for 2 hours here. That also in the vital part of the body, this portion, the spinal, which connect
Where was
the
the
brain.
injury? Let's see.
This here, you know.
This is
Back of the neck here.
8 centimeter deep.
It's in centimeter.
So, but did you ask this question to the doctor?
I may not ask you, but
No, it's all right. Did you ask this question
no,
to a doctor
didn't ask you.
that a person who has suffered,
This guy of jury.
no, a person who has suffered 8 centimeter deep, 6 centimeter wide, and 10 centimeter. All right.
Yes, Your Honor.
See, this is where is the injury? Which part?
On neck, Your Honor.
Back side of the neck.
Back of the neck.
Back of the neck.
In the spinal, that portion of the spinal
8
cord.
centimeter means it will come to the half. His neck might be hanging.
Yes, yes. And length sideways is 10 centimeter.
Nobody will have a 10 centimeter neck.
That's what I'm
Huh?
saying.
The doctor evidence himself is not believable.
That's from his postmortem.
What was the breadth of his neck? 10 centimeter. Okay, but then 8 centimeter deep inside the neck.
Yes.
Okay, but did you ask this question to the doctor? A person who has suffered a cut injury on the back of his neck with
6 centimeter.
with the injury 8 centimeter deep, 6 centimeter wide, and 10 centimeter, how long can he survive?
No.
How much blood is there in human body? How many liters? 5 liters? How many liters? I don't know. So he will die of hemorrhage, na?
Yes.
All the blood will flow. With this kind of injury, how long a person can survive?
No,
Did you ask this question to the doctor?
I may not ask, but
Yeah.
check it, looking at the time, 2 hours after the incident, the alleged incident, they go to call PW3 and come back. It's around 2 hours.
So he might have that time covered it.
One more.
Not necessarily these cuts. It was not an exposed cut, and the blood was flowing from those cuts.
Yes, more next
Yeah.
line, abdomen fine healthy and this, cervical vertebrae were surveyed at C2 and C3 level with laceration.
What is C2, C3 level?
This is the level, in the spine,
Yes.
C1, C2, C3, C4, down the spine. Yes.
Let's read.
Looking this person,
Abdomen finding
a
is healthy.
person who
Cervical vertebrae were served at C2, C3
If you
level.
look at this definition, it will make a person unconscious and unable to breathe with this kind of injury.
Show me the medical jurisprudence.
Yes,
Show me the medical science that when the medical.
I'll bring later, I'll just give it.
We are passing judgment now. What is it? Show me the medical science says so
Okay,
that
just-
with this C2, C3 level of laceration, a person. I agree with you. When the spinal cord is abdomen finding is healthy, the scalp is served at C2, C3 level.
Yes.
Laceration of vertebrate arteries and also laceration at the membranes covering C2 level, where contusion of brainstem and laceration of spinal cord at C2. Oh. Then did you ask that with these kind of injury, a person
No.
will be in a position to speak? If a person's spinal cord is served, then does he loses the ability to speak?
I didn't ask. That's not.
So neither you are a doctor nor I am a doctor.
Yes.
So if you have some expert opinion on that matter, then we can act upon it. Unless if we find that the expert opinion is not believable, then we have to go for another expert opinion. But from where you're saying that with this kind of injury, a person cannot speak.
No, I'm not saying that, I'm just.
Yes, it has got a bearing.
There's possibility that because
No, not
2
impossible.
hours, imagine if person was untreated for 2 hours.
Why should we imagine when the evidence are here? Imagination, or we don't decide matters of imagination and hallucinations. When the matters are here, we are applying our mind on these facts.
Yes.
All right. We cannot get into some fantasy world and start imagining about it. We are just talking about this is medical science. Now with these injuries, a person can survive how long? How can a person, because I agree that these three evidence of PW2, PW4, PW5 clearly reveals that the person was lying in the field.
Yes.
So if the person was lying in the field, it is nobody's case that after they saw the person lying, the deceased lying on the field, he was further assaulted by somebody else. It's nobody's case.
Yes.
Whatever the injury was to be inflicted was inflicted to him, and he was lying with the injury, and those injuries were the cause of death. It was not that PW2 and PW4 and 5 they saw and they went to call PW3. In the meantime, some more people were involved in causing further injury. That's nobody's case. So, if these injuries has got two important things. One, whether with these kind of injuries, a person, because this spinal cord means your brain goes.
Brain goes. Yes.
He says, look at the evidence. There is a contusion of the brain stem.
Yes.
No, because it is not question of just injury. We are not deciding. This is not a case where we are deciding that the injury causing death. But with this injury, can a person speak? With this injury, a person can be in a fit state of mind? But you also did not cross-examine. Your argument has to emanate from the evidence, no?
Yes. Sir.
Then what is there?
To rebut, I'll place one judgment. So,
What on
regarding this?
On what?
Regarding this dying declaration,
What is that?
this if run alias Naka and state of Uttar Pradesh.
What is the
Para
law?
61 and 62,
Ah.
where they give
You,
how.
all of you are relying on the same judgment that Irfan.
Yes.
We have read 3 judgments I'm writing on the dying declaration. So all of you have supplied. I've read about it. Para 60 and 62.
Yes, sir.
What it says, read the last part.
Last part of
What it says that it is not exhaustive, it is just a kind of a guideline.
para 62,
Now what the last part, it called out the factors which needs to be taken into consideration. What are the things which needs to be looked into in para 60 and 62?
Yes, yes.
The
Where the
Supreme Court
person,
said that these are the things, these are important things which needs to be looked into,
Yes.
but it is not exhaustive.
yeah, it is so mentioned in subclause 10 whether the
But you see,
whether as per injury
60, if you read the 62, please read 62. How is it
That-
applicable to your case?
that
How is it applicable to your
No,
case?
no,
You
in
referring to
this-
60?
in this
Come to the points. Come to the ratio laid down by the what is the law laid down by the Supreme Court on that. Come to para 60. How it is applicable to this case? Please read how many points it has been given. How many points given there?
11
11 points. How is it applicable to you?
in this point 11 whether,
How?
whether
Any
as
of the
per
point-
injury
Ah.
would be possible for deceased to make dying declaration.
All right, with nature of injury
Looking
one.
into injury part.
All right.
And
Did you
that's-
ask the doctor?
No, Your Honor.
Then, from where your argument is that with this kind of injury it was not
And
possible
also
to speak?
in para 5, 6, 7
See
whether
this,
the dying
you are missing the
consistent throughout.
bus. You are missing the bus. This has come in the context of written dying declaration. We are in a case of oral dying declaration.
Yes.
Okay. So you are referring to section 60, 62. That has come in the context of a, look, many of the points are not relevant to this case.
On the inconsistent also,
Inconsistency way.
with the previous 3 and other.
Yes. That we have already pointed out. That's why I said don't repeat
Yes.
what we have got. It is there. That inconsistency is there.
I'll
But then
rely on this
that judgment para 1662 is in the context of written dying declaration. The law says what? Is there is 2 types of dying declaration, oral dying declaration and written dying declarations. Usually what happens is that when a person is about to die, the investigating officers will make a prayer and a magistrate will go and record a dying declaration. Then before recording a dying declaration, magistrate will try to get a certificate from the doctor whether the person is fit to make a dying declaration, certificate from the doctor. Thereafter, the dying declaration will be recorded. It is always advisable that the dying declaration should be recorded in a question and answer form.
So, Your
All
Honor,
right. So that is a formal dying declaration.
So
These dying declarations, we can understand that when a person is about to die, you'll call a magistrate or you call a doctor. What will a common man do, a layman do? When a person is about to die, they'll call a doctor, isn't it? They will provide him, they will take legal actions or they'll provide medical aid. Medical aid, isn't it?
So I
So-
conclude my argument, on this part,
That-
first
that
the
okay.
FIR, there's
Yes.
the
Yes.
name.
There
with,
anything else?
And also the
The
inconsistent.
judgment that
with
Irfan one, if you have some better judgment to tell me that, I think Patrick Dhar, na?
Yes, yes.
One matter be convicted.
Yes. All cases.
Your case,
Yes.
there I would relied on oral right declarations. I refer to 2015 judgment, the Justice Deepak Misra's judgment. The matter came up from Assam. That where it said that the oral dying declaration also can be relied. Or because first I had to cross the hurdle whether oral dying declaration is admissible under law. He said it yes, and that is why it says that just because the dying declaration was not recorded formally, it does not mean that it should be discarded. But then oral dying declaration, we have to be very careful. We have to be very careful because the person before whom he made, what was the distance, whether it was possible for him to hear, anybody who was present there who also heard, and what he heard, if all are in same voice, then we can understand. Because you don't get the a chance to cross-examine the person who said he's dead.
Yes, sir.
So
But-
that Irfan one, I don't think
Okay.
so it helps you.
I
But there are
conclude-
some decisions relied while passing the Irfan's judgment that may help you. Because it gives the sum and substance of dying declaration. They say that dying declaration is a substantive piece of evidence. It can form a piece of evidence.
There should be.
But if it inspires confidence on the court, it can also be the sole basis for convicting the court. But if it does not inspire the confidence of the court, we will not just discard it. Okay, then we will look for corroboration. See, you read section 137 of the Evidence Act. Section 37 is very important act of the Evidence Act, which says that to prove one fact, one witness is enough. It is not the number of the witness, it's the quality of the witness. But why do we have so many witnesses? It is sometimes when we don't have enough sufficient evidence to prove it. So we prove it through circumstances. There are two ways of proving it, either through direct evidence or through circumstantial evidence. Is there any other way of proving the case? So she has missed out only on that. That is what I was expecting her to argue. I was hinting her that there may not be direct evidence. But look, still I can connect the dots through circumstances. The man was lying dead. Two persons went down there. Then the man was still alive. When he was taken to the hospital, he was alive. Or he died after 3-4 hours. So in all these circumstances shows that, for one thing, it shows that he was lying in the field. Thereafter, he was with an injury. 3 people saw them. Then they came back. They interacted with him. There was an interaction. And then what was the interaction? That perhaps maybe they are villagers. They could not articulate it properly. But the fact remains is they might have named 2%, 3%. But the person is here. So that please try to understand that judgment you are referring is that it may help you, but the other judgments, but we see that you apply your common sense. All the grounds set out or the factors set out by the Honorable Supreme Court in that Irfan's case, some of the factors, when you go through those factors, don't you think that it is not applicable in oral dying declaration? So it is meant for written dying declarations. So if you have some judgments on oral dying declarations, that the oral dying declaration should be impeccable, should not suffer from any flaws, then we can look into. Yes, if you have any.
That's all. My first is that the FIR. Second, inconsistent with statement of PW 2, 4, 5 with PW 3. And the same witness who stated 2 accused stated before the PW 11 only 1. And PW 5 in her 164, she was silent about the name. However, court she came with 2 names. And also, non-comply of section 27, And apart from this dying declaration, there's no corroborate other evidence, And also, I will be relying on the medical.
We don't want to keep any matter reserved because matters I don't want to keep any reserves. We have kept a lot of matter reserved, not being able to deliver judgments. So after lunch, we'll dictate. We'll be here because I might go wrong on some facts. It's easy for me to dictate in presence of the lawyers because you can help me while dictating. We'll take it up after. Any these authorities you're relying is this? This is a recent judgment of 2023.
I'll bring one more. I have to
No, I wanted that,
now.
that evidence that with such evidence, with such medical evidence, with such kind of a cut or this laceration in the spinal cord, 2-3 level, and laceration in 2-3 level of the spinal cord, and cervical vertebrae.
Yes.
Served at 2-3 levels. They use the word served. With these kind of injuries, you can't say a person because spinal cord cut, and that too, and there's a contusion. When we dictate, please tell me that what is the implication of a contusion in brain stem? Contusion means swelling. No? If there's a contusion in brain stem, can a person be able to speak, or will he be in the sense with this kind of injury? Was it possible for a person to make any declaration with these kind of injuries? If you can satisfy me only on this with this injury, I have got the expert's opinion that it is impossible for a person to make any declaration because very vital organs which connects human mind is disconnected because it's used the word served. So when these nerves are disconnected from your brain, I mean, like, you don't exist. All right. So PW 2, 3, 4, 5, 6, we'll just throw it off. When a person is not fit to make a dying declaration, what is the significance of that dying declaration? If you can convince me only on the medical evidence.
Yes, sir.
Just this paragraph, which paragraph? This 1, 2, 3, fourth paragraph. The fourth and fifth paragraph.
Fourth and fifth.
The injury in the fourth and fifth paragraph of the evidence of the doctor, PW6, makes impossible for a person, medically proved that it is impossible for a person to make declaration. He loses his sense. His body is not connected to the brain anymore. Then it's over. Then we will not look at any evidence. Only on this point we'll close it. Why should we waste time by discussing things which is not relevant? When one issue dislodges, because the entire case stands on the dying declaration, isn't it? Yes. But not the dying declaration also. But let me tell you that your investigation is not clean. Not clean. Even if they want to help somebody for whatever reasons they want to help, pass on the information that one or two cases. So one case I'm still waiting. I'm doing some research on DNA. For some cases I will not go for compensation. I ask to prosecute them. Asked to prosecute them. So, but then even if they want to help somebody, how can they make it so obvious? Witness coming and telling in the court, these two persons are involved in committing a crime. You say, no, I have investigated. They are not involved. And when we put your trial, your investigation on trial, then it emerges that the person whom you have given a clean sheet, he's the main person. In that case, what is to be done? Tell me. Tell me what is to be done. I'm just telling you, nobody will do it, but I'll do it. I'll invoke my power under section 319 and make the IO invest and accused. He is the accused. Like the yesterday's case, because the IO is dead. We'll invoke power and make the IO an accused. So obvious. Is it not so obvious that he discharged? And where is this person? He will know his friend. Where is the other person? He's facing trial somewhere else. Where is his other person? His friend?
No, it's in the village.
Village. He's his friend.
Purlok me nyuling well. Purlok me. Gitu.
Orang Sepang dia itu rayu berasa bila mandi dia. Jar.
Okay, after lunch we'll sit again. Got anything?
An argument.
Her learned counsel. Her learned prosecutor Srimati Sonso. You can sit. Her learned prosecutor Srimati Sonso. Her learned defense counsel Sri Sonso. Before this court undertakes the exercise of evaluating the evidence, it would be appropriate to marshal the facts of the case. Instant criminal proceeding was set in motion by the FIR dated 23/4/2016. Filed by one H. Satwai,
Satwai.
before the officer in charge, Satsama outpost. Stop. The informant had alleged in the FIR that on 23/4/2016, bracket Saturday, at around 2 p.m., her husband, Shri Kalla Rupon, who was cultivating ginger at a place called, in inverted comma, Hali, 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 Lanak, Lumbak, Kwa. Suddenly, Yunus Kandai, you got the name, right? Yunus Kandai and Yunus Kandai, Linewell, Lian, Linewell Sethwai, and his friends appeared and killed her husband with a dao, using a dao, by inflicting injury on his neck. The husband, before his death, revealed the name of the culprits, revealed the name of the assailants. The FIR was forwarded to Joe IPS and it was registered as Joy PS case number 85/4/16 under section 302/34 IPC. The case was taken up for investigation by SI R. Dharna. Stop. During the course of investigation, the IO made a seizure of one khasi dog length 1.2 inches and a bamboo stick. The IO visited the PO, prepared a sketch map, took photographs of the PO, held inquest over the body of the deceased, the body of the deceased was sent for post-mortem examination. Statement of the witnesses was recorded under section 161 of CRPC. The IO had also recorded the statement of the vital witnesses under section 164 of CRPC. The accused person's name in the FIR was arrested. The investigation concluded in a charge sheet. Being CS number 120/16 dated 23/9/2006 against the accused Yunus Dakhar. Yunus Kandai under section 302 IPC. The IO did not find sufficient evidence against the accused. As such, the IO prayed for discharge of the accused. The charge sheet was laid before the committal court. It is opposite to note, take note, that the committal court did not give any heed to the prayer of the IO for discharge of the accused. And in a very cavalier manner, committed the case to this court for trial by committal order dated 21/12/2017. It was expected from the committal court to issue notice to the informant before accepting the prayer of discharge of the name accused in the FIR. Stop. No, by order dated 11/5/2018. There are materials on record to show that copies were supplied to the accused before. Copies or the copies of copies were supplied to the accused. The copy of charge sheet. Copy of charge sheet was supplied to the accused before committing the case for trial. Next paragraph. The trial commenced after framing charge against the accused under section 302 IPC, the accused pleaded not guilty and demanded trial. The prosecution during the course of trial examined 13 witnesses and exhibited 13 documents. The details of the prosecution witness and the exhibits finds place in annexure in appendix 1 and 2 of this judgment. Stop. Next paragraph. The accused was examined under section 313. Thereafter, he was given an opportunity to bring defense witnesses. The accused declined, as such, the matter proceeded for final argument. A prosecution argument. Learned prosecutor submitted that the informant is the wife of the deceased She has stated in her evidence, she has stated in her testimony that on the day of the incident, she was at home and she was informed about the incident by one Lamphang Kothang at around 2 to 2:30 p.m. She went to the PO. However, no, she wanted to go to the PO. However, she was not allowed by her relatives. The body of the deceased was brought home. Body of her deceased husband was brought home, and the last rite was performed on the following day. PW1 came to learn from the co-villagers that the accused was the perpetrator of the crime. She lodged the FIR, Exhibit 1. PW2, prosecutor submitted PW2 stated that the incident took place on 23/4/2016. On the day of the incident, PW2 was collecting vegetable in a jungle called Baku, along with PW4 and 5. They saw Killa, Killa, they saw Killa lying on the ground. They approached PW3, lying on the ground. They saw it lying on the ground. They approached PW3, who was at a distance, and they returned back to the place where Killa was lying and found some other people were also present. PW3 inquired from Killa with regard to his injuries? Killa revealed that the accused Yunus and Linwell had assaulted him at the back of his neck. PW2 saw cut injury on the back of the neck of Killa. Statement of PW2 was also recorded before the magistrate under section 164. However, the same was never exhibited. Never exhibited?
Exhibited through the
Hmm?
through the witness. It was exhibited through the witness, not through the magistrate.
Exhibit?
PW 2 no.
Huh?
Exhibited only for PW 1 and 5. 2 no, not exhibited.
Or exhibit 2 no.
However, it was not exhibited.
Exhibit 2 PW 1.
So I just like to interrupt you. The 164 statement of PW1 and PW5, not this PW2. This 164 was never recorded of one of PW2. 164 of PW5 and PW1.
See the evidence. PW2 state evidence. See, my statement was recorded by the magistrate when I came to court earlier. However, the same was never exhibited. No, however, the same was not exhibited. Stop. See, she stated that. PW3 has also deposed in line with the evidence of PW2. Stop. The prosecution has emphasized on the evidence of PW3 and submitted that the deceased made an oral dying declaration before PW3. Stop. PW3 testified that while he was working in the field, PW2, PW4, and PW5 informed him that something wrong has happened to Killa Tupon. They all proceeded to the place of occurrence. They were accompanied by some more persons, namely Helen Singshai, Phan Kothang, Biang War, Multi Mutson, full stop. PW3 stated that he saw the deceased lying on the ground with his face facing towards the ground, with the injury on the back of his neck. PW3 the deceased told PW3 that it was Yunus who had assaulted him. Full stop. PW3 rushed back to the village to inform the relatives of Killa. PW4 the prosecutor submits that the testimony of PW4 fortifies the contention of the prosecution that the deceased made an oral dying declaration PW4 was present when the deceased PW4 was present when the deceased was lying on the ground alive, and she heard the deceased disclosing to PW3 that the accused Yunus had inflicted the injury. PW5 supports the evidence of PW5 supports the testimony of PW2 and PW3, and it supports the evidence of PW2 and PW3 that the deceased made an oral dying declaration to PW3. Stop. The learned prosecutor, drawing attention of this court to the evidence of the doctor PW6 who conducted postmortem, submits that the injury found on the body of the deceased was an incise injury at the back of the neck, 8 centimeter deep, 6 centimeter wide. The length of the injury was 10 centimeter. There was also bruise in the right lower abdomen. The doctor also found cervical vertebra, VER, cervical vertebra, cervical C, were served at C2 hyphen C3 level with laceration of vertebral artery. Laceration of membranes covering the spinal cord at C2 hyphen C3 level. There was a contusion of the brain, laceration of the spinal cord at C2 hyphen C3 level. The doctor PW6 opined in the postmortem report exhibit 5 that the cause of death was due to penetrating chop wound at the back of the neck with serving of C2 hyphen C3 joint and laceration of spinal cord at C2 hyphen C3 level, resulting in massive hemorrhage. And the object used for causing the injury was a sharp cutting weapon. The postmortem report is exhibit 4. PW7 is the investigating officer of the instant case. The prosecutor submits that the prosecutor has established that he conducted inquest over the body of the deceased, exhibit 6 is the inquest report. An injury found in the inquest report corroborates with the evidence of PW 2, 3, 4, and 5. Two, three, four, 5, and 7. Yeah, and 6. Doctor. Doctor 6, huh? The testimony of the IO reveals that the accused had visited the PO and prepared a sketch map, Exhibit 8. Further, the accused had led to the recovery of the weapon used for the commission of crime, and it was seized by Exhibit 7. The IO has stated he recorded the statement of 4 witnesses under Section 164 during investigation. PW8 is the Caesar witness. The testimony of the Caesar witness does not assist much, does not carry any value for the prosecution case, inasmuch as PW8 stated that he did not know, he was oblivious from where the Caesar was made. The testimony of PW9, a Caesar witness, does not help the prosecution case. The testimony of PW10 with regard to the involvement of the accused is in the nature of hearsay evidence. He is a attesting witness of the sketch map. He is attesting witness of Exhibit 6 is. What is Exhibit 6? He is a attesting witness of the inquest report. PW11 was the then secretary of Mungor village. He is also an attesting witness to the inquest. PW12 was the then officer in charge of Joy police station. He had registered the FIR and approved the filing of the charge sheet. PW 13 is the magistrate who recorded the statement of which witness? Has recorded the statement of PW1 under section 164. Full stop. Learned prosecutor argued that the deceased had made oral dying declaration before PW4, PW3 that the accused Yunus had inflicted fatal injury on the back of the neck of the deceased and caused his death. The testimony of PW 3, 4, and 5 establishes that they were present when they were present and they heard the deceased revealing to PW3 the name of the assailant, full stop. The prosecution has established that the deceased made an oral dying declaration before PW4 and the oral dying declaration of the deceased corroborates with the testimony of the doctor PW6 and the inquest report exhibit 6. Full stop. The prosecutor further submitted the seizure of a weapon used material exhibit 1. SB material exhibit 1. Material exhibit 1 corroborates with the testimony of PW3 and the post-mortem report exhibit 4. Full stop. The prosecutor, the learned prosecutor submits that the prosecution has established that the accused Yunus Dakhar had inflicted fatal injury on the back of the neck of Kalla, that is what? And caused his death. The act of the accused amounts to culpable homicide amounting to murder, and prays for conviction of the accused under section 302 IPC. Stop. Next one. The Defense Counsel, Sri so and so. At the very outset, submits that the reliance placed by the prosecution on the testimony of PW3 is highly misplaced. Comma, inasmuch as the testimony of PW3 suffers from serious discrepancies and cannot be construed as an oral dying declaration and cannot be construed as an oral dying declaration. Stop. Learned Defense Counsel submits that he would demonstrate the flaws in the prosecution evidence, rendering it unreliable, comma, unworthy, are to be considered for the purpose of convicting the accused. Stop. The defense has pointed out the discrepancies in the testimony of PW1 and the facts alleged by PW1 in the FIR Exhibit 1. Stop. The defense counsel submits that PW1 has alleged, and the PW1 has stated in the FIR that her deceased husband had disclosed the name of the assailant. However, before this court, PW1 testified that she learned about the involvement of the accused from the co-villager. Further, in a statement under section 164, have been exhibited? No. PW1?
PW1 exhibited.
In a statement under section 164, exhibit 2. No. What's the name of PW1?
Island Site 1. It's Site 1.
PW2 is the statement of Tamon Biam. No. What was
Exhibited as Exhibit 2.
Okay. How is the statement under section 164 CRPC? She stated that PW3 informed about the death of her husband. They informed about the incident and the involvement of the accused person. The defense has also brought to the notice of this court that PW1 in the FIR Exhibit 1 PW1 in her testimony before this court has stated that she was informed about the incident by one Lamprang Khatong, who never appeared before this court as a witness. Full stop. The above discrepancies seeks the credibility of the testimony of PW1. PW4, the defense counsel drawing attention of this court to the evidence of PW1 stated that to the evidence PW1 submitted that PW1 has only named the accused Jonas Kandai in a testimony. However, in the FIR, she had named two accused persons. Full stop. The defense counsel questioning the oral dying declaration submitted that PW2, 4 and 5 were present when the purported oral dying declaration was made by the deceased to PW3. Full stop. PW2, PW3, PW2, PW4 and PW5. No, PW2 no, PW2 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 heard the accused Aeolus and Linewell assaulted the deceased, colon, PW3, PW4 heard that the accused Jonas was the assailant. PW5 heard Jonas and Linewell were the assailant. And PW3 stated in his evidence that the accused Jonas was the assailant. The testimony of the witnesses who were present when the deceased made oral lying declaration before PW4 is inconsistent. As such, the same cannot be relied. Full stop. The learned defense counsel are drawing attention of this court to the testimony of the IO submits that seizure made by the IO White Exhibit 7 of Material Exhibit 1 is no seizure in the eye of law. Inasmuch as the IO had failed to comply with the statutory requirement envisaged under Section 27 of the Evidence Act. You said something about PW 11?
Yes,
What is it?
secretary. That both there are two ladies in front of PW 11 name only your decision. Para 3 of his evidence. And thereafter they went to file the FIR with PW 1. Where in FIR naming 2 with others.
Post on. The prosecution has also drawn attention of this court to the testimony of PW 11. To impress upon this court that the testimony of PW 11 cannot be relied, as PW 11 has stated that who is this Nom Dakhar and Rakhel Dakhar? PW?
PW 3 and one is PW 2. Yeah. And this is
As PW 11 has stated that PW 1,
2 and 4.
PW 1,
Nom is
PW 2,
PW 2.
PW 1, PW 2, and PW 4. They stated that PW
2 and 4.
PW 2 and 4 came to his residence and informed that the accused, Jonas Kundai, had committed a murder of Killarapon. And they went to file the FIR Exhibit 1. However, the facts alleged in the FIR runs contrary to the testimony of PW 11. learned defense counsel, in order to butter his argument on oral line declaration, has placed reliance on Irfan Ilyas Naka versus State of Uttar Pradesh, 2023 SCC online SC 1062. Relevant paragraph is paragraph 60 and 62. Stop. Where the Honorable Supreme Court had curled out factors to be taken into consideration while evaluating dying declaration. The defense counsel concluded the argument by submitting that the facts alleged in the FIR has not been established. Reliance placed by the prosecution on the testimony of PW3 suffers from serious contradiction. Seizure made by the IO is no seizure in the eye of law. The oral declaration or oral line declaration made by the deceased before made by the deceased to PW3 is surrounded with doubts. Stop. The prosecution the defense appraised for the acquittal of the accused. Stop next slide. The argument by the contending parties has given rise to the point hereunder for determination. Number one, only one. Whether the accused inflicted fatal injury on the back of the neck of Kalyan using material exhibit 1 and caused his death, and the act of the accused is culpable homicide amounting to murder. Whether on 23/4/2016, whether unto inflicted fatal injury on the back of the neck of Kalyan while he was cultivating in the ginger field. What is that place? Ginger field situated at? Huh?
Alimanak bom.
Lanak
Ali,
Dom Bakwa.
Ini berarti kamu. Stop. Next para. The testimony of PW1 informant reveals that she was informed about the incident by Lam Prang Kothang. However, in the FIR, she is silent about Lam Prang Kothang. PW1 is silent before this court with regard to her deceased husband, revealing the names of the assailant before his death. PW1 stated in a testimony that she came to learn about the incident from her co-villager. Put some those mosquitoes in. PW1 is also silent with regard to the deceased making any oral declaration before her death in a statement under section 164 exhibit 2 in her statement under section 164 of CRPC exhibit 2. PW1 has stated that the accused Jonas and Linewell were involved in causing death of her husband in the FIR, as well as in her statement under 164 CRPC exhibit 2. However, before this court, she has only named the accused Jonas conduct. Stop. This court finds the testimony of PW1 suffers from serious infirmity. The facts stated in the FIR has not been established. Person name in the FIR the facts stated in the FIR has not been established. That's enough. Stop. The testimony of PW1 also reveals that she is an illiterate person and the FIR Exhibit 1 was prepared by somebody, by the headman, and she had simply put the signature. Stop. FIR is the starting point of the investigation. The facts alleged in the FIR was investigated. The prosecution did not find any evidence against one of the named person in the FIR. After thoroughly investigating the case, which only shows that the FIR was prepared by a person none other than PW1. Stop. With the discrepancies and the omissions noted above, the testimony of the PW1 becomes very vulnerable. Stop. However, it cannot be discarded at the threshold. As such, other prosecution evidence is scrutinized. Stop. From the argument of the prosecution, it can be discerned that the prosecution is heavily relying on the testimony of PW3 on the ground that the deceased had made an oral dying declaration. Full stop. Before this court, evaluates the evidence of PW3, it would be appropriate for this court to comprehend the evidentiary value of a dying declaration through the prism of Section 32 of the Indian Evidence Act. There is no dispute that a dying declaration is a substantive piece of evidence and it is admissible under law. A dying declaration can be an oral dying declaration or a written dying declaration. Full stop. The juristic theory regarding the acceptability of dying declaration is that such declaration is made in extremity when a person is at a point of death and where every hope of this world is gone, where every motive to falsehood is silenced, and the man is induced by a most powerful consideration to speak only the truth. No man will like to meet his creator with a lie in his mouth. Stop. The precedent relied by the defense and the relevant paragraph 62 is reproduced. 62 and 63. Full stop. Keeping in mind the sanctity of a dying declaration and the safeguards, the testimony of PW3 is evaluated. PW3 testified that PW2, PW4 and PW5 informed him that something wrong has happened to Kalyan report. PW3 rushed to the place of occurrence along with PW2, 4 and 5. PW2, 4, 5, PW2, 4, 5 and some other villagers. On reaching the PO, PW3 found Kallan Rupon was lying on the ground with injury at the back of his neck. Full stop. It is natural for a person to inquire when he sees an injured person. PW3 inquired from Kallan Rapon, Koa injury. PW3 yeah, injury. Yeah, Kallan Rupon or Koa injury. Kallan Rupon confided on PW3 that the accused Yunus Kandai assaulted him. Full stop. Up to this part, the testimony of the prosecution appears to be believable. However, the testimony of PW2, who was present there along with PW3, reveals that she heard that the accused, she heard that the deceased revealing the name of Eunice and Linewell as the assailant. PW4, who was present along with PW3, names only the accused, present along with TC, heard the name of only accused Yunus. PW5, who was present along with PW3, heard Kallan disclosing the name of Yunus and Lanwell. The testimony of the PW3 confirms that PW2, 4 and 5 were present. In fact, they were the one who led PW3 to the PO. The testimony of PW3 is not consistent with the testimony of PW2, 4 and 5. One may argue that these are omissions. However, Eileen is the what?
Eileen Saitama.
On examination of the statement of PW5 under 164, Exhibit 3. This court finds she's silent about the accused, the deceased making any declaration, or revealing about the cause of death. Full stop. From the testimony of the PW3, it is also found that there were many other persons present when the deceased revealed about the cause of death. They were Shri Plen Sangai, Shri Pan Kothang, you can Shri Biangwar, Shri Multi Mutson. None of these persons were examined as a witness. To fortify the prosecution's case of an oral dying declaration. Full stop. The other factor which raises a serious concern with regard to the deceased making oral dying declaration is the state of mind of the deceased. When you say it was half an hour distance?
Not half hour,
Ah.
2 hours from PW 3 in cross, not 3, 2, 2 in cross examination. The distance between the place where Kala was lying on the ground and the place where Netser Motson was walking is about 1 to 2 hour walking distance. And also in the statement of PW
Where?
cross examination of PW 2,
Where?
next page, of the cross. Para 3, the distance between the place of Kalarupan was lying on the ground and the place where PW 3 was walking is about 1 to 2 hours walking distance. And also in the statement of PW 4, cross, in line number 3. My husband was walking about 1 hour walking distance.
Okay. The other factor which raises serious concern with regard to the deceased making oral dying declaration is the mental state of mind of the deceased. Full stop. The injury found by the doctor, PW6, appears to be a very serious injury. A person had suffered incised wounds at the back of the neck, 8 centimeter deep, 6 centimeter wide, and 10 centimeter long. With a contusion in brainstem, laceration in the spinal cord, with a massive hemorrhage, left unattended, for an hour, for an hour, for an hour or more. Can he survive to make an oral dying declaration? Full stop. The testimony of PW2 reveals testimony of PW2 and PW4 reveals that the place where they saw the deceased lying is at a distance of it is at a 1 hour or more walking distance to the place where PW3 was working. Full stop. PW3, 4 and 5. PW2, 4 and 5. After seeing the deceased lying on the ground with his injury, walk for an hour or more to disclose about the incident to PW3. And they came back only to see the deceased was alive and he made an oral lying declaration. The nature of injury found in the post-mortem report raises serious doubt on the fit state of mind of the deceased. Stop. While evaluating the evidence, it is not only corroboration or contradiction determines the evidentiary value, but a statement, if on the face of it is not acceptable by a prudent man, it will be rendered unbelievable. It is very hard to believe that a person with an injury described in the postmortem report exhibit 4 on the vital part of the body was lying on the ground profusely bleeding for more than an hour with a contusion in brain and laceration in spinal cord would be in a position to make an oral line declaration. When the oral line declaration is surrounded with doubts, or for that matter, any testimony which raises doubt, rule of prudence demands corroboration. Stop. This court finds that there is no corroborating evidence to support the testimony of PW3. The medical evidence belies the logic of a man suffering from serious incised wound, profusely bleeding for hours, was alive to make a oral dying declaration. To stop. The contention of the prosecution that the accused led the recovery does not pass the test of recovery being made in accordance with law. Any recovery made or being led by the accused is admissible under Section 27 of the Evidence Act. However, the recovery has to be made after recording after preparing a recovery memo in presence of independent witnesses and thereafter proceeding to the place for recovery along with the independent witnesses. This procedure prescribed is not merely a formality, it is for the purpose of ensuring that the recovery does not suffer from the vice of duress and coercion by the police. One may not lose sight of the fact that the recovery is made when the accused is in police custody. Unless the element of voluntariness is not established, there is a strong presumption that the accused was forced or coerced for recovery. This court finds that the prosecution has failed to establish beyond reasonable doubt that this court finds for the reasons discussed above, the prosecution has failed to establish beyond reasonable doubt that the accused Yunus conduct had caused death of Kalyan on 23/4/2026. Stop. Consequently, the accused is acquitted of the charge under section 302 and set at liberty unless wanted in some other case. Bail bond of the accused stands discharged. I was directed to destroy the material exhibit. He stands disposed of. See, we are not being very technical also now. Very frankly speaking, if you become very technical na, in this trial, in this case, old cases, none of the cases will survive. None of the cases. I don't have any hesitation in saying that. Please, I told you so many times, crime being committed by the accused and the crime being established during trial is another thing. Okay. How can we cannot have any imaginations or have some kind of a fantasy. Well, one hand, when the witness says that the distance is with that kind of injury, somebody can be alive for 1 hour. I'm aware that it might have been extracted during cross-examination, but it's there on evidence. What can I do? I just cannot throw it out. It has come in evidence. The witness has said that it is a 1 hour distance. 1 hour distance, walking distance to go, and 1 hour, 2 hours, a man with such kind of injury. Can you imagine what is the injury? 6 centimeter.
8.
Length is 10 centimeter. And 8 centimeter deep means half the neck. And spinal cord gone. 2 hours with such kind of on the back. Do you think person can survive? Is it then if you calculate also that and calculate also all the blood will be drained. If not, even if he's alive, he's not in a position to. Not in a position. You go and cut a buffalo. Buffalo also, if you cut the neck half, within 15 minutes, he's off. He may be alive, but not his body will move only. So with such kind of evidence, I don't say that you not tried well. You tried your best. Okay, what can we do? Oral evidence. No, but there are some cases we understand.
Yes. Because lots of contradiction also.
No contradiction. That is what I'm saying. The contradiction. The difficulty is here is what let the airmen themselves file the FIR. What they do is they prepare the FIR and ask the wife to file. Poor lady, she does not know anything.
What is the
That too written in English. Admin may know all the facts about the case. What stops him from becoming the informant? He's at least better placed than those villagers. Na? So most of these things, it happens. It's an old matter. It's recording under 164. But I'll tell you one thing also.
And then PW3 also, his 164 statement was never recorded.
No, not only that.
He's the most important vital witness.
I don't understand is that the statement of the POXO cases recorded of the victim under 164 is important because that 164 is chief. You don't need to examine him in chief again. The defense will only cross-examine. But in these regular cases, 164, it spoils the case. Spoils the case. So in these cases, if you go very carefully, under 164, those witnesses have said something and before the court something. That means they made one is wrong, isn't it? If the 164 statement does not tally with the statement before the court, that means one of the statement is wrong. Both the statements are on oath. Two contradicting statements on oath cannot coexist. Huh?
Yes.
Chalo. Enough. Enjoy your football. Huh? You watch football? No.
Watch.
What time?
Evening is 11:30.